Hello and welcome back to the Analyst by Vajiram and Ravi, dated 6th May 2025. Today again we will be discussing some important topics that has appeared in today's The Hindu and The Indian Express newspapers, which are very relevant for your examination. In our first topic, we will look into various aspects of Collegium system in India, its evolution and associated concerns. Then in our second topic, we'll look into the issue of digital intrusion or cyber attacks, some possible reasons and the legislative and institutional measures to address the same. After that, in our simplified section, we'll take up 5 articles and we will try to explain them in simplest language possible to enrich your understanding of the newspapers. Additionally, we have also incorporated some prelims pointers which is going to be very crucial for your upcoming prelims 2025 examination. So have a look on them also and stay tuned. So let's start our discussion with the first topic, that is Collegium system in India. The context of this topic is that just a week before his appointment, Justice Sanjeev Khanna on Monday made public details of the Supreme Court Collegium's recommendation for the appointment of the High Court judges. And this is the context, and this particular topic pertains to syllabus of your GS paper 2, Judiciary and the Indian Constitution. And the data that were published says that in last around 2 to 2.5 years, almost 406 candidates were recommended by the Supreme Court Collegium for the appointment. Out of those 406, only 221 have been approved by the government. Rest of the names were either rejected by the government for the appointment or they are pending before the government itself. More than that, the data also gives us detail that the names that were recommended, the 406 names, only 34 names were belonging to women candidates. Other than that, only 32 candidates were from other backward classes and 8 candidates were from scheduled caste and 7 from the scheduled tribes. That also gives us a picture about one of the major issues associated with the judiciary is the lack of representation of the backward classes, lack of representation of women as well as the marginalized section in the judiciary. So when we are talking about the Supreme Court Collegium, what exactly is this Collegium and the Collegium system in context of India means? Collegium, literal meaning is a group of people who join together for a common purpose or for a common cause. And in context of India, Collegium system refers to a system of appointment and transfer of judges for higher judiciary, that is Supreme Court and the High Court, and which is a unique feature of India and not visible in other democratic country like United States. So how exactly we have reached to this Collegium system? Interestingly, it is not backed by any statute or the law of the parliament, and explicitly it is also not mentioned in the constitution itself. So what exactly constitution says regarding the appointment of the Supreme Court and the High Court judges? Article 124 and Article 217 talks about the appointment of Supreme Court judges as well as the High Court judges respectively. So Article 124 subclause 2 says that the judges of the Supreme Court are appointed by the President. So the appointing authority is the President. But she should consult such a number of judges of the Supreme Court and the High Court in the states as she deems necessary for the purpose of appointment. And Article 217 says that the judges of High Court shall be appointed by the President in consultation with the Chief Justice of India and the Governor of that particular state where the High Court is located. And the Chief Justice of High Court should also be consulted except in case of his or her own appointment. If there are other judges who are being appointed in that particular High Court, then the Chief Justice of that particular High Court should also be consulted. But Constitution doesn't explicitly says that what does this consultation means. It is the concurrence of the opinion or it is just an opinion. Whether that opinion which is given by the Chief Justice of India or the judges of the Supreme Court and the High Court, are they binding on the President, are they binding on the executive or not? So this is with the help of these Supreme Court judgments, Supreme Court gave the answer of this particular question, that who exactly has the primacy over the appointment process of the Supreme Court and the High Court judges. Is it the executive or is it the judiciary have the primacy in the appointment? So for the first time in the SP Gupta versus Union of India case of 1981, which is also famously known as the first judge's case, the question came in front of Supreme Court that who has the primacy over the judicial appointment. And the verdict that Supreme Court gave was that executive has the primacy. Supreme Court said that the consultation under Article 124 doesn't mean concurrence. That is, the President is not bound by the advice standard given by the Chief Justice of India. However, in the next case, that is Supreme Court Advocates on Record Association versus Union of India case 1993, which is famously known as the second judge's case, the Supreme Court overruled its previous decision and said that the Chief Justice of India's advice is binding on the executive, is binding on the president. And the CGI is required to formulate its advice based on a collegium of judges consisted of CGI and the two senior most Supreme Court judges. So it is not only the opinion and advice of the Chief Justice of India itself, rather he should or she should consult two other senior most judges for giving that advice to the president. So in the second judge's case, we actually got the form of the collegium which we are witnessing at present. However, again, in one of the president's reference case under the Article 143, under Article 143, the president have power to consult with the Supreme Court on any matter of law or fact, or any pre-constitutional treaty or pre-independence treaty. The president can consult the Supreme Court. The president can ask for the opinion of the Supreme Court. And under Article 143, where the president has referred to the Supreme Court expanded the collegium to a 5-member body to include the Chief Justice and the four senior most judges of the court after the Chief Justice of India. So in the second judge's case, it was only CGI plus 2 senior most judges, whereas in the third judge's case, which was a president's reference case, in this particular case, we witnessed the present form of the collegium system, that is 1 CGI or the Chief Justice of India plus 4 other senior most judges. So it was made a broader body, a bigger body as compared to the second judge's case. And this is the present form which we are witnessing for the collegium. After that, in 2015, the executive or the government tries to reform this collegium system, and they pass this NJAC or National Judicial Appointment Commission Act with the help of the 99th Constitutional Amendment Act in 2015, where the central government said that the appointment would be done by Chief Justice of India, Supreme Court judges, plus the law minister will be part of that NJAC, plus 2 eminent jurists will be part of that particular NJAC, and this body which have the CGI, Supreme Court judges, law minister plus 2 eminent jurists who will be appointed by the president, they will be recommending the names for the appointment of the Supreme Court and High Court judges. However, it was struck down by the Supreme Court, and Supreme Court said that it is against the independent functioning of the judiciary. So what is the composition as present of the collegium system? It is a 5-member body which is headed by the incumbent Chief Justice of India, and it comprises 4 other senior most judges of the court at that point of time. And then we also have the High Court Collegium, which is headed by the incumbent Chief Justice of that High Court itself, and 2 other senior most judges of that court are part of that High Court Collegium. And by its very nature, the composition of the collegium keeps on changing. With the old members retiring, new member takes place or take a seat in the collegium. What are arguments in favor of this collegium system? So there are various experts, there are various people who says that the collegium system is very significant for the independent functioning of the judiciary, and it upholds the Article 50, ensuring that judges are not appointed by the executive completely. Rather, it should be an independent appointment process where the executive do not have complete primacy. So it will ensure that the judiciary is not motivated, not influenced by the executive's decision, and it is also ensuring that the separation of power, the doctrine of separation of power is also intact, and there is no or less executive control in the functioning of the judiciary. Also, it maintains the doctrine of separation of power. You people tell me in the comment box that who was the philosopher who gave this concept of the separation of power. So here in the doctrine of separation of power, it prevents the government from influencing the judicial appointments, and it also keeps a check on executive overreach, and that avoids the stacking of the courts. That whatever the appointments that will be done, they will not influence the judgments of the Supreme Court, because in many of the case it is the central government who is party in various cases. For example, as of now, the validity of the Waqf Amendment Act is in front of the Supreme Court, where one of the party is the central government itself. So when the central government or the executive will have a primacy over the appointment process, it might lead to the judgments that will be coming, that might be influenced by this, the primacy of the executive. And that is the reason it ensures that there is judicial supremacy in the appointment process, and that will ensure that objective, transparent decisions are coming without any favoritism. Also, it leads to insulation from the political inference, because what happens that judiciary is the final interpreter of the constitution, and it ensures that it is interpreting the constitution, it is interpreting or looking into the validity of various constitutional amendment without influence of the executive. For example, if you talk about the Keshwanand Bharati judgment, if you talk about the ADM Jabalpur judgment, which was not in line with the central government's view, which was against the view of the central government, and it wouldn't have been possible as per various experts if the appointment was highly influenced by the executive. Since the judiciary have a primacy over the appointment process, and the officers who, or the people, the justice, the chief justice as well as other judges who were holding the office, they were giving their judgments without any impact of the executive, and that is the reason they were able to uphold the constitution. They were able to give that judgment which became very significant in India's journey of the evolution of the constitution. And it also maintains the judicial integrity. That what happens, that judiciary can protect its independence through the contempt proceedings which are provided, and those who try to undermine it. And it will also ensure that there will be ethical conduct of the judiciary, of the people who are holding the offices under the judiciary, because they are not influenced by the executive appointment process. Also, it ensures that the appointment which are coming, the collegium ensures that there is proper checks, there is proper background check that is happening. So that ensures that there is a proper screening during the appointment process is happening, to ensure that ethical conduct is being maintained in the judicial offices. Also, insulation from the political interference. That what happens, that generally there are involvement of the Senate in the United States. So it is generally believed that when the executive or the legislature will have a say in the appointment process of the officers or in the judiciary, the judgments might be influenced, whether it is the constitutional validity of the amendment in the constitution, or whether it is about any law, or whether it is about any of the cases which is going on about any of the legislature or about any of the MPs. When they will have a say in the appointment process, then that might lead to impact on the judgments that will be coming by the Supreme Court. So that ensures that the judiciary is insulated from the political interference. But there are various concerns with the system. First of all, it is completely non-transparent, that there is no official mechanism with the help of which we can get an official minutes of the meetings of the collegium. There is no secretariat of the collegium which can release the timely updates related to the various decisions that were being taken under the collegium. That why exactly a particular name was recommended and why rest of the names were not recommended. What is the rationale? What is the objective criteria? What is the appointment process? What is the qualification, exact qualification that Supreme Court Collegium is looking after? We do not get a proper data related to that. Also, which leads to a chances of the favoritism and the nepotism. Because generally it is believed that when we are not giving a clear idea about the qualification, for example, when you people are preparing for the UPSC examination, UPSC has given a clear-cut qualification criteria that you are a person who should be either qualified or who should be appearing or already got the degree, bachelor's degree. That is the qualification criteria. Your age should be above 21 years. Similarly, there is lack of exact or transparent objective criteria related to the appointment process of the judiciary. So that leads to a chances of the favoritism and the nepotism of the people who are already part of the judiciary, people who are already part of the collegium. Also, the exclusion of the executive may lead to favoritism. It may lead to further ensuring that there is no proper screening. For example, executive have various other agencies which can help in getting a proper background check of the people who are getting appointed in the judiciary. So when we will involve the executive, it will lead to better decision making, as well as of now what we have discussed, that 406 names were recommended, but only 221 were finally appointed. Rest of the names are either pending with the government or they were rejected. But when executive will be part of this system of the appointment and the recommendation of names, it will lead to faster decision making. The appointment process will be ensured in a time bound manner, because executive is also part of the decision making, and it will also help in addressing the issue of the judicial pendency of the cases and the absence or the vacancies in the offices of the judiciary that might be addressed properly. Also, it is a completely closed door affair. There is no accountability of this collegium system, that why exactly a particular decision was taken. We are a democratic country, and we generally promotes a transparent process, that public offices should be open for everyone, and whatever the decisions that are coming, the people should have the right to know, until and unless it is undermining the national sovereignty or the integrity, it is related to the security of the nation. So people have the right to know the data related to that. But when it is a complete closed door affair, we do not have any idea about it, it is against the accountability, it is a complete opaque process. Also, it is against the principle of the checks and balances, because checks and balances ensures that there is no overreach of any one particular pillar, whether it is the judiciary or the executive. When executive will also be the part of this appointment process, that might ensure that there is no judicial overreach, and no public knowledge of how and when the collegium meets and how it takes decisions. We do not have any clear idea about the decision making process, that what exactly is the mechanism with the help of which the collegium is actually deciding the cases. Also, the official minutes of the collegium proceedings are not also coming in public domain. For example, generally the minutes of the cabinet meetings are released by the government to give an idea that what was the agenda of the meeting, how they have decided, what are the various decisions that they have already taken. And that is again, after every cabinet meeting, you will see one of the cabinet minister will come and they will give the various decisions that were taken, whether it is related to farmers, women, or any of the government schemes. They will tell that we have decided this, but there is no official minutes which are released by the collegium regarding their proceedings. So we again do not get any idea that how this particular collegium is functioning. Also, the lack of inclusivity, as we have seen that when the judiciary do not have the proper representation of women, scheduled caste, scheduled tribes, other backward classes, so obviously they are also not represented well in the collegium. And when they are not represented, experts believe that is the reason the representation of women and the other backward classes have been abysmal in the judiciary. So what is the way forward? How we can address this issue? First of all, there can be a permanent independent body which may have the representation of the executive. For this, a proper consultation needs to be done between the judiciary and the government, so that we can get a body which can recommend the names without favoritism, without nepotism. There is a proper transparent objective criteria based on which names are recommending. It will also help in faster clearance of names or faster approving of the names with the help of the government, because government or the executive is also part of that body. And there is need for institutionalizing the process. Judicial primacy should be done, but it should not be judicial exclusivity. The primacy of the judiciary should be maintained, so that their independent functioning is maintained, so that they are not interfering, they are not influenced by the politics of the nation, they are not influenced by the executive. But this should not be a complete exclusive body of the judiciary itself, rather it have representation of some other people. And there is inclusivity that is important, and that is the reason the memorandum of procedure which the collegium generally follows for the appointment and the recommendations, they need to be reformed, so that the inclusivity happens, that people of different genders, people of different caste, etc., or the people of different marginalized section are also represented, so that we can get a proper representation of all sections irrespective of the class they belongs to. And this will also lead to timely filling up of vacancies. For this, again, there is need for a proper communication between the government and the collegium, because there is no explicit criteria or there is no explicit time within which the particular judgment or the particular appointment decision should be taken by the government. And that is the reason when the government is not part of that decision making process, the names are pending before the government itself, they are not taking any decision. So that is leading to vacancies in the judicial offices, that is leading to pendency in the cases. And that is the reason if we will make some amendment in the appointment process, if we'll make some amendment in the body that is recommending the names, that will also lead to timely filling up of vacancies. We can also look into some of the best practices which are being followed in various other countries. For example, in USA, the appointments are made by the president, judges of the Supreme Court are nominated by the president and confirmed by the United States Senate. Whereas in UK, the Supreme Court judges are appointed by a 5-people selection commission. And Supreme Court President, his deputy and 1 member each appointed by the Judicial Appointment Commission, which consists of laypersons, member of judiciary and the bar of England, Scotland and Northern Ireland, and they are actually recommending the final names. Similarly, there has been various editorial which have been written in the newspapers. They have also recommended that there can be one body which have the representation of the bar, that is Bar Council of India, means some advocate, senior advocate will be part of that. Executive can be also given the representation, and some eminent jurist who can be recommended by a committee whose member can be the Chief Justice of India, Prime Minister and any other person. And those eminent jurists, those persons who are representing the bar as well as the executive along with the CGI and the senior most judges of the Supreme Court can lead to a broad-based body which can lead to a more inclusive appointment candidates coming in the judiciary. This is a prelims PYQ which was asked from this topic. This was asked in 2019, which says that the 44th Amendment to the Constitution of the India introduced an article placing the election of Prime Minister beyond judicial rule. This is incorrect. This was 39th Amendment, and the Supreme Court of India struck down the 99th Amendment to the Constitution of India as being violative of the independence of the judiciary. That is correct. Correct answer is B2 only. Apart from that, this is a mains practice question that you people can write from this topic. Moving further to our next topic, that is menace of digital intrusions. The context of this topic is that Pakistan-based groups tried to gain unauthorized access to the sensitive data belonging to various public sector undertakings in the defense sector. And this particular topic pertains to syllabus of your GS paper 3, challenges to internal security through communication networks and the basics of the cyber security. And this is not new. Even if you'll recall the Galwan classes which happened in year 2020, after those classes, there were various attempts that were done by the Chinese-based groups to attack various vital installations of India. So whenever we have some tensions, border tensions going on with our bilateral neighbors, so in those cases, these kind of things become much visible. And that is the reason we need to ensure that our vital installations are properly intact, there is proper cyber hygienes that are being maintained. And these public sector undertakings has completely denied that there was no compromise of the data and all the data is completely intact. And this topic cyber security is very important in last few years, in last 10-12 years. You can see that consistent number of questions were asked from this particular topic, and that is the reason this topic is very important. Now let's try to look into some background and some data related to the cyber crime or the cases. In the initial 4 months of 2024, there was 63% surge in the cybercrime cases, and India experienced almost 7,000 complaints every day since the 1st January 2024 till April 2024. And the number of complaints were related to digital frauds, trading scams, investment scams, as well as the dating scams. This is the data related to the cybercrime in India. Also in 2024, in the initial few months, there were almost 7,40,957 cases of the cyber crimes, whereas in year 2023 more than 15 lakh cases were related to the cyber crimes. And there are different types of cyber crimes. For example, phishing, which involves obtaining the personal information of the user by sending spam mails or by means of phishing websites, which resembles the same as the authorized websites. That website will look similar to the original, but it is not. And whenever people will visit that website, that will lead to the compromising of the data, personal data of the person. Identity theft, that involves getting an information about the credit card or debit card or the bank details. Further, unwanted money can be easily detected after the information is hacked. Malware attacks, which is the hostile software which is designed to damage the computer or the system. This is done to access the meaningful information for doing some crime by using that system. Also, the ATM frauds, cyber stalking, spoofing, which is an email received and appears to be from some authentic source, but it is not same, it is corrupted. Then the piracy, which is unauthorized access to the information which is confidential. Many of times the government websites are hacked and files are pirated containing the important data. That leads to pollution of that important data. So what are the different reasons, important reasons for the cyber crimes? First of all, the most important are the political reasons. As of now, whenever bilateral tensions increases, this is another front that we have to fight, because whenever such important data is compromised, that leads to economic losses, that leads to losses of the personal data of the people, the privacy is compromised. So this is again one front which is sponsored by the various state actors, as well as various non-state actors also wants to take the advantage of this front. More than that, the transnational nature of the offense, that the people who are doing this kind of crime, they are sitting outside the country. So obviously they are outside the clutches of the security agencies, and this transnational nature of the nature further motivates people to go for this particular type of crime. Also, there are various state sponsored attacks. Time and again there has been various reports that we saw that there were Chinese based groups which were attacking our vital installations. The Mumbai power grid which was attacked, the server of the AIMS which was attacked, the administrative wing of the Kudankulam power plant which was attacked. There were various state actors whose involvement came in light by various reports, by various media reports. And similarly, the recent attack that we are seeing, that is again the Pakistan based groups are trying to compromise our data. Another important factor is the economic reasons. For example, the ransomware attacks that happens. So these kind of ransomware when happens, that leads to non-accessibility of particular website or app of the data of the people. In that case, all the attackers, they want money, especially in the form of the crypto, etc. And when the victim gives that money, only then they will be able to access their data, their websites or their apps. Similarly, it involves whether we talk about the digital frauds that are happening, the dating scams that are happening. Everywhere, or in the most of the cases, it is the money that is involved. And because of the poverty, because of this greed of getting too much of money, people generally resort to these kind of illegal activities. And if you want to talk about the international dimensions, more than it is the economic reason, it is the security dimensions, that whenever, let's suppose, any of the vital installations that is getting attacked, so that leads to law and order situation, that leads to compromising on the safety of the particular nation, security of the particular nation. The sovereignty and the territorial integrity might be compromised whenever such kind of attacks are happening. And then there are some social reasons when we talk about the digital frauds that are happening inside the country itself. Because if you look into one of the web series which came on Netflix, the name of that web series was Jamtara. Jamtara is one of the districts in Jharkhand. What happened there? That initially there were few people, there were few youth who resorted to these kind of digital frauds, where they were taking OTP of the people, where they were phishing kind of attacks they were doing, or they were doing the debit card or the credit card related frauds. And these youth or young people, when they got too much of money by resorting to these kind of digital frauds, that they bought various luxurious vehicles, they bought SUVs, they built lavish homes. So in that case, other people were also motivated, other young people were also motivated to come for these kind of digital frauds. So already these are some of the districts where there is high poverty. For example, some of the districts in Haryana, some of the districts in Jharkhand, etc., where there is high poverty, people do not have the proper resources. People, when they do not have the proper resources, obviously they are not getting proper education, they are not getting proper employability, that is leading to low productivity of these people. And when they have the low productivity, further they will perish into the poverty. And in this case, when they do not have proper job, proper education, low productivity, and when they gets one of the opportunity where they can go for the digital frauds, from where they can get easy money, obviously they resort to these kind of things. So with the increasing population, low education, low employment, which is further pressing people into the poverty, as well as the peer group motivation, which motivates other people, it leads to the increase in the tendency of the cyber crime. This is a vicious cycle. So how this can be addressed? By proper oversight mechanism, by proper enforcement of the laws. More than that, there is need for proper improvement in the social economic indicators. And this is where, when one of the district magistrate when joined, Mr. Faj, when joined the Jamtara district, he opened various libraries in the Jamtara district so that these people who have low education can get proper education. Based on that, when they will understand the importance of education, they will not resort to these kind of digital frauds, rather they will be attracted towards the education. And this has actually helped in significantly bringing down the cases of the digital fraud. So the punitive measures as well as the education and other measures can help in addressing this issue properly. There are other technological advancements which has happened. For example, artificial intelligence, cryptocurrency, machine learning. Then new equipments has been formed. When the technological advancement has actually happened, it has also made it much easier for attacking, for going through the digital frauds. More than that, when we know that we are highly dependent on various products on the China, on various other countries, we are importing various components, whether it is related to mobile phones, whether it is related to various other vital installations. So obviously we are prone to these kind of attacks in time of any of the when the bilateral tensions are high. So that is this technological advancement as well as the import dependency is also making it more vulnerable for these kind of attacks. Then the legal reasons, that we do not have any comprehensive law which can actually tackle this dynamic nature of cyber frauds which are happening. The IT Act is there, but that is again the new forms of the crimes that are happening, that is not addressing them very well. What are the current provisions of the cyber security? For example, the IT Act 2000, which is the governing ministry, is the Ministry of Electronics and IT. It provides the legal framework for the e-commerce, digital signatures and cyber crimes. It defines the penalties for the cyber offenses like the data theft, hacking, etc. Then we have the IT Amendment Act, which happened in 2008. It introduced the section 66A, which was struck down later. You people tell me in the which particular famous case Supreme Court struck down this section 66A. And then section 69, which gives the government interception powers, and it added data related to the protection. It recognized the electronic signatures. Then we have the National Cyber Security Policy 2013, which aims to create a secure cyber ecosystem. And it also focuses on computer emergency response team, critical infrastructure protection, as well as increasing awareness among the people. Then we have the Computer Emergency Response Team, which is under the Ministry of Electronics and Electronics and IT, Information Technology. It is the nodal agency for cyber security threats, and it monitors cyber incidents, issue alerts, and the coordinated response is done by the Computer Emergency Response Team. Then we have the Indian Cyber Crime Coordination Center, I4C, which is under the Ministry of Home Affairs. It has 7 components, including the Cyber Crime Reporting Portal. It coordinates the investigation, and the cyber forensics is being done by the I4C. Then we have the National Critical Information Infrastructure Protection Center, which is under the NTRO, that is National Technical Research Organization. It protects the critical infrastructure, whether it is the banking related infrastructure, whether it is the power grid, or whether it is the telecom related the infrastructure. It is designated under the IT Act 2000 section 70A. So what should be done to address the issue of the cyber crimes? First of all, India should consider joining the Budapest Convention on the cyber crime. That can actually help in tackling the transnational nature of the crime in a well manner. There is need for proper budgetary allocations that needs to be done, especially for addressing the issue of the cyber crimes. Because when we have a proper budgetary allocation, we will be able to create that architecture in a proper comprehensive manner that can make us less vulnerable to these kind of attacks, these kind of cyber crimes. Also, there is need for stricter enforcement of regulation. For this, there is need for proper training that needs to be provided to the security agencies, security forces, that they can understand the various nitty-gritties of the changing nature of the cyber crimes, and they are well prepared to address that. More than that, there is need for a proper oversight mechanism which can address this issue. Along with that, for example, UP government, they have opened cyber thanas in every tehsil. So similar kind of things needs to be replicated in all the states, because when we will have a dedicated cyber police stations, that can actually motivate people to register the cases and which can minimize the cases of the cyber crimes. Also, there is need for basics cyber security habits that needs to be followed. For example, lock your computer properly, verify each request that you are getting, update everything, whether it is the software, etc. Look before you click. Whatever the particular link that you are getting, until unless it is from authorized sources, don't click on that. Authorize it with the proper channels, with proper person, that whether that is the proper link, whether that is the real link or not. Also maintain password hygiene. Make a proper strong password rather than only keeping it 1 2 3 4 5 6 8 7 9, and have a regular backup of all your data, so that if the data is lost, you do not have to bear a lot of losses. Apart from that, there is need for proper collaboration and the communication between the various agencies. We need to ensure that whatever the multilateral organizations, bilateral treaties we are signing or discussions we are doing, whether at multilateral forum or the bilateral forums, cyber security remains an important agenda for that particular meeting. This is a mains practice question. What are the major drivers of the growing threat of the cyber crimes in India? Suggest some measures to address the issue comprehensively. Please write this question. Moving further to our simplified section, first topic is triple test to determine OBC quota in Jharkhand. This particular topic pertains to syllabus of your GS paper 2, Executive, Indian Constitution, Fundamental Rights and Judiciary. And this has appeared in today's Indian Express, page number 14, that is the explained section. So the Jharkhand has finished the data collection on the population of other backward classes in the state, and this is the step one is called the triple test, a 3-step guideline which is laid by the Supreme Court to ensure the OBC quota in the local bodies are set to they are in fair and constitutional manner. And from where we have got this triple test, it is from this judgment Vikas Krishna Rao Gawali versus State of Maharashtra and others on March 4, 2021, which are the 3 tests. One is that there is need for setting up a dedicated commission to conduct a rigorous empirical inquiry into the nature and the implication of the backwardness in the local bodies. That what is the nature, that whether it is not only the representation that is the concern, or they do not have the proper powers, or is there any other concern related to their representation. That needs to be first empirically verified with the proper data collection with the help of a proper dedicated commission. Also, specifying the proportion of the reservation that is required in local bodies in light of the recommendation of the commission. That commission should recommend that what should be the particular reservation that should be provided, so that now these people can be represented well in these urban local bodies. Also, ensuring reservation for SC, STs, OBC taken together does not exceed the 50% of the total seats. So the 50% ceiling limits should be followed properly. So the Jharkhand Mukti Morcha's Nand Kumar Mehta, who was a member of OBC commission, he said that survey will primarily help the identify the number of OBC voter in the urban local bodies, and final report will also include data on the political representation of OBCs across various tiers of government, from mayors, which is generally in the municipal corporations, to Panchayats committee member, and data on the caste compositions of Jharkhand MPs and MLAs. Also, in various Supreme Court judgment, Supreme Court gave its opinion related to the reservation. For example, in Indra Sahni versus Union of India case, which is also called as the Mandal case, because it oversaw the recommendation of the Mandal Commission, and this judgment came in 1992. The key issue was the OBC reservation, the creamy layer, and the 50% cap on the reservation. Supreme Court upheld the 27% OBC quota. It introduced the creamy layer exclusion, that people who have already taken the benefits of these reservations, they should be excluded from getting the reservation benefits. Also, there was 50% cap on the total reservation with some exceptions that were provided. Then the M. Nagaraj versus Union of India case that came in 2006, where the key issue was whether SC, ST promotions in the government jobs should be allowed or not. So it allowed reservation in promotions, but state must prove the backwardness in advocacy and the administrative efficiency. That there should be empirical data that should be presented by the government, which will show that there is lack of representation of these SC, ST population, as well as it is not impacting the administrative efficiency. Then Ashok Kumar Thakur versus Union of India case, which came in 2008, it provided 27% OBC quota in central institutions. The Supreme Court upheld the OBC quota in educational institution, and again it excluded the creamy layer from the benefits. Then Janit Abhiyan versus Union of India case, which actually came to look after the validity of the EWS case. You people tell me in the comment box that which was the constitutional amendment done in the constitution with the help of which there was 10% reservation that was provided to the economically weaker section, and this judgment came in 2022. This was 10% EWS quota. The answer is in front of you itself. It was the 103rd constitutional amendment itself, and it upheld the 10% reservation for non-OBC SC/ST. It excluded the SC/ST OBC from the EWS benefits. Then state of Kerala versus NM Thomas. It provided relaxation in qualification for SC/ST employed. It allowed the concession for SC/ST in promotions. It affirmed the reservation as part of equality under the Article 16, Part 3 of the Constitution. Then another EV Chennaiya versus State of Andhra Pradesh case of 2005, subclassification within SC/ST itself. It struck down Andhra's supreme scheduled caste subcategorization. Only Parliament can modify SC/ST lists. This was said in this EV Chennaiya versus State of Andhra Pradesh. Next topic is that who gets a voter ID and how. This is related to your GS paper 2, elections, constitutional bodies, and this has appeared in today's Indian Express page number 12. So among the 100 of Pakistani who were ordered to leave India in wake of the terrorist attack in Pahalgam are some who claim to have the valid Aadhars, ration card, and even Indian voter IDs, who came to India and now they are having these important documents in India itself. And after math of the Pahalgam attack, obviously the government has taken various measures. They have kept the Indus Water Treaty in abeyance. Apart from that, they have also asked the various Pakistani nationals to leave India and they should go to the Pakistan. Now, how exactly the person can become a voter? How can they get the voter ID? Under Article 326 of the Constitution, it says that every person who is citizen of India and who is not less than 18 years of age and is not otherwise disqualified on certain other specific grounds shall be entitled to be registered as a voter in Lok Sabha, State Union Territory Assembly elections. Also, the Election Commission of India's Form 6, the form of registering new electors, requires the applicant to provide self-attested copies of the proof of age. That what is the proof of age? For example, class 10th mark sheet can be one of the proof of age, and address proof, that can be the ration card, the bank passbook, etc. The form includes a declaration of citizenship, and while no proof of citizenship is required to be presented at that time, if the declaration is found to be false, applicant can be jailed up to a year and or fined under the section 31 of the 1950 Act. Then the determination of citizenship, according to Election Commission of India manuals on electoral rolls, the Electoral Registration Office is responsible for making sure that no ineligible person is added to the electoral roll. And if the claim is presented before the ARO that there is a person who should be ineligible to be part of that electoral roll, the officer has to satisfy himself that the applicant is inter alia a citizen of India, says the manual. And AROs must apply their minds independently without being influenced by any of the other consideration. And in case of the application from a migrant from within India, the ARO has to cross-check the particulars with the district election officers of the district from where the application was actually belonging to. And married women, in case of married women who has changed her address as a result of marriage and who cannot produce the documentary evidence as proof of citizenship, the ARO can rely on the proof of being registered as a voter as an unmarried person. And in such case, the ARO can also rely on the proof of marriage, that is the marriage certificates, or any certificate that is issued by the headman, that is Pradhan or the Sarpanch of the villages where the woman lived before the marriage and after. And according to the sources in Election Commission, non-citizens getting voter IDs have been discovered in the past as well. And whenever objections were found to be true, the electors have been struck off from the electoral rolls and action has been initiated against them, whose names were actually found to be. Now there are different forms. For example, Form 6, we talked about new registration in electoral roll and change of address from one assembly constituency to other. Form 6A, which talks about registration as an overseas elector. Form 7, objection to the inclusion of a name or request of the deletion of a name. Form 8, correction in the details of entry in the electoral roll, for example, name, father name, etc. if you want to rectify. Form 8A, transposition of any entry from one part to another part of electoral roll within the same assembly constituency. Also, if you look into the general hierarchy, at top it is the Election Commission of India, then it is the Chief Electoral Officers, then there are district level officers, then there are Electoral Registration Officer, Assistant Electoral Registration Officers, and then there are booth level officers who actually help in conduction of that elections at each booth itself. These Chief Electoral Officers are generally at the state levels. Our next topic is appointment of the CBI director. This is related to your GS paper 2, government policies and interventions, and this has appeared in today's Indian Express page number 1. So the Central Bureau of Investigation Director Praveen Sood is all set to get a one year extension as the high level committee which actually picks the director of the CBI, which consists of Prime Minister, leader of opposition in the Lok Sabha, as well as the Chief Justice of India, could not arrive at a consensus on the shortlisted names. And official notification regarding the extension will be issued by the Department of Personnel and Training, which is the nodal ministry for the premier investigative agency. Now, this is one confusion that you people have. The CBI is under the Ministry of Home Affairs. That is not correct. Nodal agency for the Central Bureau of Investigation is the Department of Personnel and Training, that is DOPT. And as per the law, an incumbent can get an extension up to 1 year as an director of the CBI. Also, CBI draws its power from Delhi Special Police Establishment Act 1946. If you look into the structure of the CBI, under the CBI director, there are 3 important wings. One is the economic offences wing, second is the anti-corruption division, and third is the special crime division. Economic offences wing have 9 units in Delhi with all India jurisdiction. Anti-corruption division have 9 units in Delhi, again with all India jurisdiction. And special crime division have also 9 units. Also, the Central Vigilance Commission CVC supervises the functioning of the CBI, as well as the Department of Personnel and Training, which is under the Prime Minister's office. They also looks after the Central Bureau of Investigation or the CBI, because CBI also comes under the Department of Personnel and Training. Our next topic is game of skill versus game of chance, which is related to GS paper 3, IT and computers, and this has appeared in today's The Hindu page number 16. So there are various litigation that are going on with regard to the game of skill and the game of chance, because that will actually determine that what should be the GST that should be levied on these apps or the companies. So Supreme Court on Monday saw the government and online gaming companies spur on whether game of skills such as rummy, chess and bridge will metamorphosis into games of chance, and their earnings will be subject to the GST regime or not. An additional Solicitor General said that game of skill would continue to be what they were until bets or wagers were placed on it, and then it will become gambling. In spite of being a game of skill, betting on a game of skill is statutorily considered as gambling itself. So what is the difference between this game of skill and game of chance? As per various Supreme Court judgment, game of skill where the player invests time in learning, practicing and honing the skills. Whereas in the game of chance, the outcome of the game depends on the factors like luck and the unpredictability of the game itself. For example, if you talk about the Dream 11 team which people makes, or the My 11 circle teams which people make, in that case it will be very difficult to decide whether that is game of skill or game of chance, because people will have to use some of their brains to actually choose that team, to decide who will be the captain, who will be the vice captain. Apart from that, how will that particular player will perform? That is also a chance, that is also a luck that will decide the results of that game. So success of the game depends on principally on the superior knowledge of the game, training, attention, experience of the player, that is the game of skill. And skills have to be predominant element in the game of skill. For example, if people are playing the chess, that can be considered a game of skill, because people are using their knowledge, they are using their brain. Whereas in the game of chance, the results are uncertain, and a game of chance is considered as gambling, and that is again that gets more GST. So in January, the top court has stayed the operation of so-called notices worth 1.12 lakh crore issued under GST proceedings against the online gambling companies, and about 50 online companies were before the top court. And the main dispute in case concerned the interpretation of the GST applicability on online gambling. The government argued that 28% GST must apply to the total contest entry amount, effectively taxing the entire prize pool. That, let's suppose 49 is being contributed by everyone, so whatever the 50 lakhs or 1 crore people have contributed, in on whole amount, a 28% GST should be there. However, the gaming companies contended that GST should only be levied on their platform fee or the commission, as many of these games involve skill rather than the chance. Next topic is Baglihar and the Salal Dams, which is related to GS Paper 2, India and its neighborhood, government policies and interventions, as well as syllabus of your GS Paper 3, infrastructure. And this has appeared in today's The Hindu, page number 14. So, India over the weekend resorted to a surprise release of water from Baglihar and Salal Dams in Jammu and Kashmir on the Chenab River. So, most important is that these two dams are located on the Chenab River, that you need to remember. While this is far from triggering a man-made flood in the Pakistan, it is the first consequential water-based action taken by India since it announced keeping the Indus Water Treaty in abeyance. Because under the provisions of IWT initially, the data should be released, the data should be given to the Pakistani authorities beforehand that we are going to release water. But now, since that treaty is in abeyance, we are not bound to give any data or give any prior information. And while such release water called flushing the reservoir is routine annual activity and necessary to clear the dams of riverine silt before the monsoon arrives and muck to keep the power plants linked to these reservoirs running optimally. It is usually done in August during the monsoon season when too much of water is supplied to the dams. The Baglihar is 900 megawatt hydropower project in Jammu and Kashmir. It has a reservoir capacity of 475 million cubic meter. Whereas Salal power project is in Raisi district of Jammu and Kashmir with a 690 megawatt hydropower project. What are some other projects? For example, on Ravi River, we have the Ranjit Sagar Dam, which is in Punjab. Then we have the Chamera Dam, which is again on the Ravi River. Then we have the Pando Dam on the Byas River, Pong Dam or the Maharana Pratap Sagar Dam on the Byas. All these three are in Himachal Pradesh. Then Bhakra Dam, which is on the Satluj River, which is in Himachal Pradesh and Punjab. Then Nathpa Jhakri Dam is again on Satluj River, Himachal Pradesh, and Koldam Dam is again in the Himachal Pradesh. The key purpose is hydroelectric power generation. That is all from today's analyst. Thank you for joining this session. All the very best. Keep studying.